You're welcome back. This is Newsfile, your most authoritative news analysis show. And we're starting right with Dr. Dodoo, who has been hauled before the Parliament's Privileges Committee. But there's another separate one, Black Rasta. He's also supposed to appear. I understand he's saying that about 56 lawyers have already, spoken to him, and they are interested in leading him there because he claimed that parliamentarians, about 80% of them, smoke weed. Well, he's clarified that he didn't say they smoke, they use. And in fact, you can find weed in various items. Well, let's see how he goes to discharge himself in the House. But we're talking about the comments attributed to Dr. Professor Dodoo, who is said to have claimed that the MPs are ignorant on the Ebola vaccine process, and therefore he's been hauled before the House. Let's hear Dodoo Ajaho, who is the Speaker of Parliament.
I will exercise my discretion in favor of the call to refer Professor Dodoo to the Privileges Committee of the House. Honourable members, I'm doing so because I've carefully listened to the Minister for Health, and some of the issues that he raised are not different from the issues that the members raised on the floor of the House. I've also read the press statement from the Ghana Academy of Arts and Sciences. Some of the concerns they have raised are also different from the concerns raised by honourable members on the floor of the House. Honourable members, even in this House, when we are legislating, perform your constitutional duty, and the public whom we represent here are not in support and think that there's not sufficient information to them, we suspend proceedings to re-engage them. And Honourable Minister for Health, I thank you very much for suspending the process. And I want to tell you, if you have not done that, members of this House from both sides have seen me to bring a bill under certificate of agency to pass it, to restrict some of the powers vested in the Food and Drugs Authority, so that the ministry can have full responsibility, and if need be, Parliament can be briefed at certain intervals on these matters.
Right, so that's the Right Honourable Speaker of Parliament, Dodoo Ajaho, and they have just summoned Professor Alex Dodoo, a lecturer at the School of Medicine and Dentistry of the University of Ghana, to appear before its Privileges Committee for allegedly attacking members of Parliament over comments they made about the suspended Ebola vaccine trial. He is alleged to have said they were ignorant, and that's what the MPs are angry about and think is in contempt of the House and brings the House into disrepute. Article 122 and Articles 123 clearly vest Parliament with the power to punish for contempt unto itself. But how exactly is it going to exercise this power? Egbert Fable Jr. was in that same situation some time back as news editor. He joins us back briefly to tell us how exactly the process is conducted. Egbert, thank you for joining us once again.
Thank you, Samson.
Great. So how exactly will this process be conducted?
Well, Samson, I think that the procedure is well laid out. The Speaker will, as has happened, will make a reference to the Privileges Committee. The Privileges Committee is chaired by the First Deputy Speaker of Parliament and not more than 30 members of Parliament. So in my case, when I appeared for the committee, Honourable Freddie Blay was the then First Deputy Speaker, so he was chair of the Privileges Committee. And I was asked by the committee to show cause why should not be referred to the Parliament as a whole, for me to stand at the bar of Parliament and, be sanctioned appropriately.
Right.
In my case, we are going to publish an article, independent, Alajiti must teach his boys and girls the discipline, the forum, and one other word that starts with a kid, and I cannot.
I remember that, boys and girls.
Yes, and so it was not an easy session. I mean, you had people from across the political divide, NPP and NDC, who felt that we had gone too far. So the first question I was asked was, so what do I have to do in showing cause that I should not be punished?
Right.
And I remember telling the honorable members of the committee that, well, I came to bury Caesar, but not to praise him. Even with this, he kept insisting that I should break it down. Am I apologizing or not? In the end, I mean, I had to weigh my options, and I apologized.
Okay.
But something, and then a reference was made, a report was sent to Parliament, and then the recommendation was that because I had apologized to the committee, the matter should be considered.
You had purged yourself of the contempt.
Yes, and
right.
Parliament itself accepted it. But you see,
right. What my next question really is, practically, how does Article 122 envisage how the power ought to be used? Is it supposed to be as we saw in the Supreme Court during the election petition, which some of us even still hold the view that Atachia's point at the Supreme Court was the correct position of the law? If it is contempt ex facie and not contempt in facie, before them, they did not have the power to seek to punish right there and then.
Samson, I must say that Parliament cannot punish anybody for contempt.
Are you serious about that?
I'm very serious about it. I'm going to draw your attention to something.
Do that quickly. Let me see.
There's a law in this country called the Parliament Act of 1965, Act 300.
Okay.
Now it says it provides among others at section 41 of it that when a stranger is found by Parliament to be guilty of contempt of Parliament, Parliament may order the stranger to appear at the bar of Parliament at a time specified in the order to be reprimanded by the Speaker. Now, you go to section 43 of Act 300. It says, section 43 was, a stranger who is guilty of contempt of Parliament is liable to a fine not exceeding 250 penalty units or a term of imprisonment of 1 year or both the fine and the imprisonment. And the subheading of that section 43 is criminal prosecution. Under criminal prosecution, section 43(1) says a stranger who is guilty of contempt of Parliament is liable to a fine not exceeding 250 penalty units or a term of imprisonment for 1 year or both the fine and the imprisonment. And then goes on to say, for example, that section 43 provides that proceedings taken in respect of an act under one or more sections of sections 34 to 42 of this act shall not affect the liability of a person to prosecution punishment in respect that act under this section or any other enactment.
Okay.
In this republic, Article 88 of the 1992 Constitution makes it very clear that the prosecution powers of this republic lie with the Attorney General, and prosecution will only take place in a court of law. So Parliament can only say that, yes, we find you liable for contempt of court, and we recommend that, or we request the Attorney General to prosecute you before court.
Okay.
You understand? Yeah, and at 300, that's the Parliament Act of 1965, is good law present in Ghana.
I see. But Egbert, how do you reconcile that with Article 123, which says that where an act or omission which constitutes contempt of Parliament is an offence under the criminal law, the exercise by Parliament of the power to punish for contempt shall not be a bar to the institution of proceedings under the criminal law?
That is so.
It sounds to me that this is a waiver, takes away the provision requiring the Attorney General to do the committal processes, so that Parliament can bring you before them and punish you in their face.
Yes, but Parliament has the power.
Okay.
That what act to commit anybody to a term of imprisonment. The same Constitution makes provision that nobody shall be punished for an offense that is not provided for in any law.
Article 1911.
Yes. Now it is coming to prosecution. Act 300 makes provision for criminal prosecution. And
all right.
at section 41 of Act 300 says, reprimand a stranger in contempt, where when a stranger is found by Parliament to be guilty of contempt of Parliament, Parliament may order the stranger to appear at the bar of Parliament at the time specified in the order to be reprimanded by the Speaker.
Okay.
So if you go before Parliament and Parliament takes a decision that, look, you ought to be reprimanded, the law is very clear, pursuant to section 41.
All right.
They can reprimand you, the Speaker can reprimand you. But the same law now says criminal prosecution and says that a stranger who is guilty of contempt of Parliament is liable to a fine not exceeding 250 penalty units or a term of imprisonment for 1 year.
So that act has varied the provision in the Constitution, not unlawfully, so to speak. So that's what we ought to abide by.
That is so.
Okay.
That is so. So
okay.
we ought to be very careful about this.
So those who are being hauled can expect that if they are found guilty, they could be reprimanded right there in Parliament.
Yes.
Could be fined, but
yes.
if they have to consider the question of prosecution, it has to be a reference to the Attorney General for the committal processes.
That is so.
Okay.
But Samson, another small point that I want to pay attention to. Every committee of Parliament, pursuant to the standing orders of Parliament, has the power of a High Court.
Okay.
But having the power of a High Court does not make you a High Court.
Right.
If you get what I'm saying now. So, for example, if Parliament decides to try anybody for contempt in absentia, the privileges come Parliament, for that matter, Parliament subject to the supervisory jurisdiction of the High Court.
Okay.
To have this decision quiet.
Right.
So why do we keep doing this to ourselves as if the Parliament has the power to commit? Yes, they have the powers of a High Court, but they are not the High Court.
Well, some of the leaders of Parliament, hold the view that they can punish immediately. Thank you very much, Egbert, for your time.
I thank you too.
Thank you very much. Now, I'll come to you, Kweku, or let's start with Haruna. You are the lawyer. Yes, what do you say? When you invite people before you summon them for contempt?
Yes, we do so in exercise of our powers under the Constitution,
right,
which is the gronom of the land. And as I listened to Egbert, whether he spoke authoritatively or convinced, he has only opined. That is not a judgment, and therefore for him to say
he referred you to an act that specifies what you have to do.
Whatever it is, he has only expressed an opinion. That is not a decision. That cannot be a decision. It is just his view in analyzing what contempt means. But I refer you back to two legal principles, and you tried, and maybe you have to help me. I don't have the criminal code given as amended. Okay. I don't want to see the head note on contempt of court, whether it was just contempt or contempt of court under the criminal code. It's
contempt of court. You
absolutely.
Find so in the civil procedure, CI 47 section order 50, you find contempt of court.
So therefore, I think that Parliament and Egbert may come to just one conclusion. He, in one breath, Parliament cannot punish for contempt. He concludes by saying that punishment can recommend for contempt. What is he saying? Read 1, 2, 3 well, and I just want to go through the text.
I read it to him.
Yes, but I want to emphasize something. Where an act or omission which constitutes contempt of Parliament is an offense under the criminal law. So what you must be finding out is whether it is an offense under the criminal law. So we have to go into the criminal code to see how contempt is saved under the criminal code.
Right.
My understanding of it is contempt of court, in facie curia or ex facie curia.
Right.
But if it is contempt just standing alone, then myself and you will have a different attitude to this debate.
Right.
But contempt of Parliament is defined by the Constitution. 1, 2, 3 is defined.
Right.
And it says, and I'm continuing the reading, the exercise by Parliament of the power to punish for contempt. It means the Constitution itself recognizes that Parliament can punish for contempt. But what the Constitution says...
So what you are saying, in effect, is that you can jail a contemnor.
No, that's not what I've said. I'm building my point. The exercise by Parliament of the power to punish for contempt, it means the Constitution imposes the authority on Parliament to have the ability to punish for contempt. But hear what the Constitution says again. Shall not be a bar to the institution of proceedings under the criminal law.
Right.
That is where I think Egbert got it right.
But I referred that to him, and he held to the position.
Even where Parliament so punishes for contempt, it may not end there.
Right.
Parliament itself may recommend criminal proceedings if it's defined under
double
the
jeopardy.
criminal code. Absolutely.
Double jeopardy.
You are raising double jeopardy.
Okay.
But it can be in the context of Egbert, I rather would take the enforcing the contempt decision of Parliament. What about that? Not a double jeopardy thing.
All right.
So I think that all of us must deal with the issue.
Is there any precedent?
Not as far as I know. When I was invited for this program and I knew this subject was going to be discussed, I bounced off some of the senior lawyers who've been in Parliament for some time, and they didn't point to any precedent, except that there was also some belief that it is time some of these provisions in the Constitution were activated so that we'll be clear in our minds, the way I got clear in my mind, that if you commented on a Supreme Court in a way, you could go to jail. That it may be useful to activate some of these provisions to see how they work out, then we can all learn. When I go back to the 123 as a non-lawyer, my understanding is that the contempt itself is defined in 122, and it says perhaps what is or affront the dignity of Parliament, or let me pick it.
An act which affronts
which affronts the dignity of Parliament, or which tends either directly or indirectly to produce that result.
Right.
Is contempt of court defined in the Constitution. And then it goes on to say that
if you are going to Parliament to do your work and I hinder you in some way, it is contempt of
that will be judged by Parliament itself.
Yeah, that's what the law says.
Exactly.
Yeah.
Whether Parliament considers that that act directly or indirectly produces that effect. And then it goes on to say that where Parliament finds you to be in contempt of it, that Parliament can do something. Parliament can do something. But if Parliament chooses to do that thing, it does not mean that all the beautiful processes that Egbert and the lawyers would love to talk about cannot happen. Absolutely. This tells me clearly that that thing which Parliament can do is different from all the other processes and the rules of court that you refer to. My simple reading of this, and it is the view of many of the senior lawyers in Parliament I spoke with, that Parliament can punish. And in fact, they did make references to a time in the English Parliament where we borrowed some of these traditions from, where they had dungeons in Parliament. So that if Parliament then punished you, I wasn't able to confirm this myself. They said if Parliament punished you, they sent you there straight away.
All right.
So I have no doubt that, my relationship with this matter is really not that Professor Dodoo ought to be prosecuted or all that. I think this matter ought to be looked at in terms of how we help each other to do the work we've been assigned to do. To describe, just 1 minute, please.
Right.
To describe members of Parliament as ignorant, for me, does not help in any way. It is like describing a matter on the economy, and I listen to a group of journalists, and I say, oh, they are ignorant. It doesn't help. If people put facts out.
You mean that's a problem?
That's a problem.
It's a problem to be ignorant about something?
When the minister said some people were asking useless questions, we all did not like it. It may well be that in his judgment, really those questions were useless.
But with the greatest of respect to the August House, I heard some people make submissions in the House. There were these ladies who made some comments. And outright, the information I have as far as the Ebola process is concerned pointed to someone who sounded absolutely ignorant about the process. The group in Ho, no, it sounds, it appears. I'm very careful. It appears even the group from the caucus, when they came to the House, read their statement, portions of their statement, suggested, confirmed certain fears of some of the people which were born out of lack of information by the people.
Good.
And that's what Dr. Dodoo felt.
Precisely, lack of information. You see,
it's a better word.
Yeah, I do not.
Let me go to Kaku.
I just wanted to.
No, because we are still on this issue.
Okay,
so yes, and a senior of mine says that the position as espoused by the two of you on Parliament's power is the correct position, and that there's no question of double jeopardy because this is an exception to the normal procedure that we know as provided by law. Kweku, I don't know what you want to say briefly about the contempt matter, but the meat of the issue for which he's being invited.
No, let me deal with the contempt aspect. See, this is a book by K.B. Ayensu and S.N. Dakwa.
Okay.
Authoritative on parliamentary history. K.B. Ayensu was the first clerk of Parliament.
Okay.
Let's go through it. Punishment of offenders. We are on the page of contempt of Parliament. It says the House has the power to protect its privilege and to impose sanctions against its breach. It is well established that without the power to punish offenders, laws will become meaningless. Although the Constitution and the standing orders of the House are silent on the kind of punishment for those found guilty of contempt or breach of privilege, the following punishments may be imposed. A member found by the House to be guilty of contempt may be reprimanded in his place in the House by the Speaker or be suspended from the service of the House.
That's a member.
I'm coming. For a specific period or expelled from the House. B, expulsion as the ultimate punishment for a member demonstrates the power of the House to regulate its own proceedings. Then it comes to a subtitle, punishment of officers and of strangers.
Right.
An officer found guilty of contempt may be suspended from duty in Parliament. It may have disciplinary proceedings taken against him by the Parliamentary Service Board. A stranger found guilty of contempt may be excluded from the presence of the House or reprimanded by the Speaker at the bar of the House or have criminal proceedings against him in a court.
Kweku, can you repeat that again?
Criminal proceedings against him
before
in
you
a
go
court.
to or have criminal proceedings.
It says a stranger found guilty of contempt may be excluded from the presence of the House or reprimanded by the Speaker at the bar of the House or have criminal proceedings taken against him in a court. In a court. Parliament is not a court.
So he's referring to the act that Egbert refers to.
I'm coming. Under Article 123 of the Constitution, quote, the exercise by Parliament of the power to punish for contempt shall not be a bar to the institution of proceedings under the criminal law. Then he ends up, Parliament itself cannot impose a fine or a prison sentence.
Perfect. I see.
Now, let me give you some little history that happened. And I don't know. I've been trying to do my checks. In the Second Republican Parliament, something interesting happened. You know, 3 Nooks executives led by the President, Alfredo Kantamaklo, were brought before Parliament because they had written a letter seeking to tell the Speaker to enforce the declaration of assets by members of Parliament and ministers of state. Okay. And they wanted an interview with the Speaker at a particular date. Their letter was dated 26th April, and they wanted a meeting on 1st of May. The Speaker was unable. They were written back. Somehow, the Nooks executive were not too happy about that. The Speaker took offense to a letter, the publication of their letter in the media, where they had, let me quote, this is the Hansard for 4th May 1971. And the Speaker's problem, yes, the Speaker's problem was that the guy, the Nooks people had threatened. No, I don't want to read the full thing because of time, but had threatened that if they didn't do the assets declaration, the members of Parliament and the ministers may have consequences to face. But I found something interesting, and that is why I said I haven't done my full checks. If there's anybody out there who is very conversant with the Second Republican Constitution, they may be able to tell us, or they are standing orders. But you listen to what happened in Parliament. They put these 3 executives before Parliament and reprimanded them before the bar. And the Speaker threatened that he had powers to actually imprison them. And I found that very, very, very weird. I'm sure you recall that. You know, he said that, look, yes, this is the speaker talking, the deputy speaker. He says, if the president of the executive committee is not aware, the speaker of the National Assembly has sufficient powers to commit him to prison from here. That is from the floor of the House. Meaning that, in his estimation, Parliament had the duties. And listen, he says, I do not intend to exercise that power on him now. I will treat the whole of his conduct and that of the members of the executive as one and warn them that Parliament is the sole judge of what act or omission constitutes contempt of Parliament, or what affronts the dignity of the House or impedes any officer or member of the House. Mr. Kwesi Lamptey, his view was this. Listen to what he said. He says, Mr. Speaker, I think we are very happy with your ruling. At the same time, one would observe that the students who have appeared before the bar of the House are improperly dressed. It is likely that in the same way that they acted and committed contempt of Parliament by the use of those statements, they are ignorant and therefore they might be forgiven for that. But I think we of this House, without any commentary on what you have said, agree with you very much and support you in your warning to them that if at any future time a thing like that happens, as you have said, appropriate measures might be taken which might incarcerate them right from this House, which is the highest court in this land.
Do you know the test of the constitutional provision regarding this matter?
But that is the point I made. That for people who are knowledgeable or who may be immediately clear on that, they could help us. But I'll be surprised, to be honest with you, if the legislature of the Second Republic had this kind of powers. I would be surprised. There was separation of powers. If I was key.
Constitution of 1969, we should be able
to but you see, it will undermine the theory of separation of powers, in my candid opinion. If Parliament were to be seized with the power to try and at the same time sentence immediately, I think it will bastardize
Montesquieu's theory of separation of powers.
Yes, but if you
do you find it in similar fashion that it will sound like an aberration of the whole democratic exercise?
Not at all. Thank you very much. I think what is happening will offer us the opportunity for institutional building and institutional learning. We are all learning, and if you look at even the English system that you were quoting, some authorities have argued that since the 19th century. Even the House of Commons has not activated that, those powers. But the last time the House of Lords used that power was in the 17th century. In fact, 1666, that's when they used it. So
that's
really,
how far back we'll be going if we attempted to use it.
But what it means
I think it's dead and buried.
So it's not, even though in theory it's there in the English though, it's an untested terrain, especially when you come to non-members of these two houses of the House of Lords and
it's interesting to me particularly because in the context of the courts, and I think we all are aware of that, if you commit contempt right in the face of the court, as in you are right before the court, and you do something that amounts to bringing the dignity of the court down, then you can be punished instantaneously by the judge. But if you did it outside of the court, you are called upon through a process to come and answer through a criminal committal proceeding, which will be initiated by the Attorney General.
That's true.
That alone should be an indicator as to what really we are talking about. I don't think Parliament has the authority.
During the Supreme petition was unlawful. I mean,
no, that was the highest court of the land.
No, there are those who take that position. There are those who take that position. That what Atachia sought to advocate in that court was the right position. That they ought to have referred the matter to the Attorney General, and the Attorney General will commence the committal proceedings for the individual so
At the
cited.
Supreme Court.
Yes,
Yeah,
to
because those
answer.
things happen outside the
To
court, the
answer.
contempt.
So they could have constituted a sole judge of the Supreme Court at the High Court, like in the Liberty Press case.
No, I have a fundamental.
Interesting.
I hope that
Yes,
you give
very
me 1
interesting.
minute. I have a fundamental disagreement, Samson, to your interpretation and understanding of this issue. Contempt of court is one of the saved provisions under the criminal code for a purpose. It is the only offense that you would it's in the bosom of the judge. Therefore, in fascicuria es fascicuria, once you are
it
declared
matters.
to
The
be
two
in contempt,
contempt.
you may not even be given an opportunity to say, I'm guilty or not guilty. So let us not miss it.
So what is the purpose?
What
was the purpose in the Supreme Court?
No,
what was the purpose of asking the
within
people
the power,
to justify why they should not be committed? What's
For
the
instance,
purpose?
maybe if you give me 1 minute, just be patient. Kweku, for instance, if you want to prove stealing, and Samson knows it, you want to prove murder, the law will tell you that establish 5 ingredients of murder. There must be murder. There must be death. The death must be unlawful. The death must have been committed by the person accused. You are establishing the ingredients.
With
In
intention.
respect of contempt, the law itself says it is a safe provision, part of the dignity and sanctity of the powers of the judiciary. You give it to them to exercise. Therefore, it is the offense for which you don't you don't need to prove and to demonstrate to the court that I've done this or not.
I do not
then
want to be
show
agreeing with you
good
because that's
behavior.
not my job here.
It's a
but
and let me
that
just
would be
tie
such
in.
tyrannical.
Yeah, that's tyrannical.
And undemocratic.
Something, give me 1 minute so that I stay off this comment.
Yeah.
With Kweku's lucid commentary on the parliamentary thing, I think what we should be asking is whether what myself and Honorable Kwarteng referred to, Article 122 and 123, did it save the contempt of Parliament under the Constitution as saved clauses?
Okay,
where,
made.
No, and I'm answering
Points
what
made.
Kweku raised.
Yes,
whether
made.
or not the Constitution is saying that yes, we recognize that there is a judicial organ of government which exercises the judicial power, but we have saved the contempt of Parliament as a power that can be exercised by Parliament.
Okay.
The two gentlemen whose the names I mentioned, as I said, they were the authorities. Of course, Mr. KBI I think is no longer. The title of this book is How Parliament Functions, an introduction to the law, practice and procedure of the Parliament of Ghana.
But Kweku, in this,
Now,
they are not just expressing opinion.
These are
They
facts.
are explaining the act that Egbert refers to.
Yes, and so I'm more inclined
Okay.
to the
Some
share
of the issues.
Egbert's view that Parliament has no power
No, but Kweku, this one-
to sentence. As they said here, they cannot even impose a fine.
But they can
Or
punish.
They can punish,
the
but you see that there's
recommend
weight.
for
No,
criminal
wait.
proceedings.
But their
That's
weight,
our
the weight
argument.
of
I mean,
punishment.
Parliament take
Excluded
decision.
from Parliament. It's a
Yeah.
punishment.
Please, the weight of punishment is apparently targeted at members. Members. Now, and the officers.
Reprimand and exclusion.
some
Get out of this
extent-
house until we are done.
Yes, but not strangers. Then we are all entitled to
one
go
minute.
before the courts.
Let's
But
move
no,
on. You
but
know,
can
I was
can I-
thinking
We
we
will
could
come to-
look at the
No, it's an
substance
important
No, I was
of the
coming to-
invitation.
No, that's what I
Let's
wanted
go
to
there. That's
come
what-
to. I have a point here. See, there's no doubt that Parliament has a right to discuss issues, to deliberate on any issue. And that issue was very critical. So what they did was okay in principle. There were many things Parliament said that day that were also very good. And indeed, subsequently when the health minister appeared, some coincidence of positions were cleared there.
Right.
But please, this is the Hansard. And my view is that Parliament is being overly sensitive relative to the Prof's team. In terms, if ignorant is the point here, I think they're wasting time, everybody's time, precious time.
Well, we are yet to see whether he used
Let-
that word or someone else
Okay,
used
but let
it.
me read this 2 or 3 things.
Okay.
This is from the Hansard, 10th June 2015. Is it good to mention the names or I should skip it?
Oh, go ahead.
This is coming from Miss Ladi A. Ayamba,
Okay.
NDC Pusika. It says, it sounded very interesting to me because I wondered. I just asked myself, trial? How do you try such a deadly and unthinkable disease that we have all prayed against on humans in no other country than Ghana, where fortunately God has protected us. We prayed fervently and it did not hit us. Why are you now trying to try it on human beings? Have we finished trying it on rats, mice, and chimpanzee, which at many times we know are used for such trials? Have we done that? Now, were we trying a disease? I'm asking, is it the disease that is being tried?
Okay, to be frank with you, she's the one I was referring to.
And not only that, listen, there are about 4 or 5 more.
No, we know, but to be fair to her,
no, you see, that's why I didn't want to mention the name.
to, for this purpose, the vaccine,
no,
not disease. So when
this is Hansard.
No, we do correction of this.
Oh no, this is Hansard. This one is the finished product. This is the finished one. It's not a draft. I know.
Okay.
Parliament is my baby.
So let's wait. Let's finish this exercise. Finish this exercise.
You see, so this is it. This is coming from a position of ignorance or lack of knowledge or lack of information, whichever way you want to call it. Ignorance is the bottom line.
Maybe I should also warn you, like I was warned by Kuku Kwatik. Be careful.
Oh, but Parliament must have a big heart. Come on. If it's different, if you scandalize them, there are ways you can do that. If you scandalize Parliament, I'll be the first to defend Parliament. It's my favorite sector of the governance structure.
Oh, I see.
Yes.
Okay.
I love Parliament.
Now continue. You were just about to
Second one, my own good friend, Mr. Katie Hammond. He says, Mr. Speaker, we should be very careful in this country. May I know where the Minister for Health and officials have been? This is completely improper. This is wrong. This is a health hazard. When one goes to Europe or all those countries we hear about testing of new vaccines and other medication, before they come on stream, serious precautions are taken to make sure that they are tested on specific animals, like guinea pigs, chimpanzees, those creatures, and eventually it comes to human beings. Truth be told, the kind of test that was going to be done here, they've passed the stage of testing on animals. Am I right?
Right.
So is this not a point of ignorance, lack of knowledge, or lack of information? Is that not so? So if somebody were even to say that some of the submissions on the floor of the House was based on ignorance, what's wrong with that? That's factual. That's a factual statement. He has not scandalized Parliament in any way. There are many more. But
maybe just do a last one, then we'll move on.
See, this is the last one. Okay, I have 2 more, but let's take this. Mr. Speaker, maybe I should mention the name. This is Gershon Bediame, NDC Kwanta South. Mr. Speaker, in my mind, if people have been infected by a particular virus, and they want to try a vaccine, good sense tells us that those who have suffered from it must first be tried to see their response to the vaccine. But I do not understand what the reaction would be for somebody who has never suffered from it. This ignorance. And indeed, fortunately, the Speaker was sharp enough to say this. Remember, is it not the case that those who have suffered from it could become immune? Is that not the normal understanding? Because what the Speaker is saying here is valid.
Yeah, valid.
But what the member has said earlier was completely based on ignorance.
All right.
Or unscientific. I rest my case.
Thank you very much. And maybe a last point on the contempt matter. If you read section 300 of the is it section 300 of Act 300 of the act that Egbert refers to, the Parliament Act, you find that it says that subject to Article 88, which is the power to the Attorney General.
Fantastic.
Subject to Article 88 of the Constitution, Parliament may order the Attorney General to prosecute a person whom it suspects to have committed a contempt of Parliament which constitutes an offence under this section or any other enactment. Yes.
No, Kweku, it cannot be. But I just cherish the fact that we're all enriching the jurisprudence on the subject. But
right.
Samson, have you ever had cause to ask yourself, Article 88, mandate of the Attorney General,
yes,
legal advisor to government, power to institute criminal and civil proceedings,
and defend.
What if the Attorney General is in contempt of the court? What happens? That is why it is saved. I'm just asking. I don't need an answer.
That's an interesting
the Attorney
one.
General, if the Attorney General was in contempt of court,
who is going to do that?
It's not the office that is in contempt. It's perhaps it's the individual.
Understand it better,
No, wait. If the individual,
understand it better, That is why it's a safe clause.
Okay.
You leave it.
No, but the office,
the
no,
I think we should be able to move on. I think we should
it's
be
an
able to move
interesting
on.
question, though. But
Right.
the individual AG, if he's in contempt,
No.
he's subject to prosecution.
Okay.
There and there.
Thank you.
The
Thank
AG's
you.
contempt
Thank
will
you.
be
Thank you.
infancy
Thank you.
in the face of
Let me
the
read
court.
some of the messages that have come in from Jerry Amponsa in New York. He says, Ebola was found here in the US, and the vaccine hasn't been used over here. Ghana, where no Ebola was found, is where the vaccine is being used.
It hasn't been used here. In the US, they've had tries there.
Yes, they have. Okay, so shall we say this is also an ignorant post? Because it's being done in the US, in the UK, and some selected African countries, including Ghana. In the UK, what I find to be interesting is that the candidates are being given close to $2,000, dollars, is it? But here we are told that we are going to be they were going to be giving 200 Ghana cedis and a mobile phone.
Not talk about that.
Yes.
He had cancelled those portions on his statement to the. So when somebody raised it, the speaker said, "No, it's not a matter before us. Yes, keep to his text." So
Okay.
that matter is also in limbo.
Well, shall we do it this way? We have run out of time, so what I'll rather like us to do is that the issue of the NPP and its primaries that we have seen last week, some very big shots were unseated.
Before
Yes,
you go on,
yeah, go ahead.
The point Kokuwaku made, is it possible to state what you consider to be a fact and yet it would offend the dignity of Parliament? Is it possible?
It depends on what the language you use.
That for instance, your father wets the bed in the night. If you said that to him in public, have you offended his dignity?
No,
certainly you
we are
have.
talking of a republic.
I know.
Parliament is an institution of governance. When you reduce it, this is an oversimplification, which will not meet the test of strict scrutiny in terms of governance.
You see,
Just one
Koku, yours was
Parliament
based on the fact
is
that
not my father.
I'm coming.
Parliament is a governance institution.
That is okay. Yours was based on the fact that yes, some members had displayed what, in your judgment, was ignorant. In your judgment,
Yes, some
what I am
indicated
saying
as
is
well.
that is it possible that you would express your views on what members have done in a way that would offend the dignity of the House? So it may not well be whether what you said is factual. It may be whether the way you communicated it has offended the dignity of Parliament. And that judgment is in the bosom of
Assuming
Parliament.
without admitting the good professor said some members or some of the things said that were based on ignorance.
Okay.
Why should Parliament be so
Before you
offended?
go to NPP
This is
primary,
nothing.
I just think it wasn't
Well,
good language.
well,
I don't feel offended, but I think it wasn't good language.
Something, one
I need to comment
second.
on
Yes.
I think that Parliament is not above criticisms, and we've never said that the institution of Parliament should not be subject to scrutiny by the public. We simply are saying that uphold the dignity of Parliament in the comments and remarks that you make.
Right.
And I wish that I
Yes.
could just make one byline on Ebola. You see, such a sensitive major public health epidemic of global stature, that you are coming to test a vaccine, that you have the Ghana Academy of Science, Arts and Sciences take a position on a matter similar to Parliament. And you raise a question, but you never answered it. And if Parliament is declared ignorant, in view of a particular position
say
that we
Parliament
took. No,
was
I'm not
ignorant?
saying. Samson said he will let us know whether he in fact said that. I didn't listen to that.
When he appears before the House.
Absolutely good. But what we are saying is that we are not above, we are not impervious to scrutiny and criticisms from the public. But people should uphold the dignity of Parliament. Appreciate that in Parliament there are scientists, in Parliament there are pharmacists, in Parliament there are medical doctors, and when it comes to some of this subject, we will yield to their expertise. But we are saying that a member of Parliament, for instance, if even one member of my constituent raises an objection to Ebola and thinks that I must let it reflect at the national level, I owe him that duty to state that my constituents are against
So I am
this.
sure that the pharmacists in
position.
Parliament
Yes,
were to make a contribution. None of them will say that you are trying the disease on us.
Yes, that's
Well, but we have subsequently even heard.
On every
We have
subject,
subsequently
there will be
heard.
ignorant people in Parliament.
So if somebody says
We have subsequently read reports attributed to the majority leader asking that Dr. Dodoo allows the vaccine to be tested on him first.
Yeah, it's in Hansard. He said
And
so.
himself, he also concluded
He
by
says,
saying
yeah,
that if he does it, then Higgbagin will now be willing.
Absolutely.
Does that help the process?
That is pathetic.
Okay. Now he mentioned the Ghana Academy of Arts and Sciences. They have actually issued a press statement, and it's surprising to hear them actually say that they have concerns. That concerns ought to be addressed. Yes. And I'll just refer to a conclusion that they refer to.
Well researched, well argued.
They say that it is to be noted that the phase 1 trial of the GSK vaccine in Europe produced an adverse event, namely prolonged bleeding, in 10% to 15% of the vaccinated population. Vaccinated population. This is a serious adverse event that calls for extreme caution in approving clinical trials, both phase 1 and phase 2 in the country. Then it says that, moreover, it is the case that those vaccinated in phase 1 and phase 2 may be shedding the adenovirus virus, vector, into the surrounding community. In the absence of a map of adenovirus prevalence in the trial sites, there is a high risk of an escape virus merging with the endemic adenovirus to create more virulent strains. I hope I don't mix these words any longer as I read the conclusion. For that reason alone, it is important that the exposed communities and indeed the general public be adequately informed of such trials and their benefits and risk. In conclusion, the Ghana Academy of Arts and Sciences wishes to state its firm position that, subject to satisfactory answers to the issues it has raised and considering the gaps in our knowledge and state of gaps in our knowledge, is that the same as ignorance? Yeah. Yes, and the state of preparedness, it would be unsafe to undertake the proposed EVD vaccine clinical trials in Ghana. Thank you very much. Make your last point.
Yes, I think that fundamentally, yes, the dignity of Parliament must be protected. I always think that Parliament, if you take the president out, it's the democratic face of the country, because literally every member there is elected.
In parliamentary democracies, yes. Have you seen what they tell the president in his face when he sits in the parliament?
Yeah, why not? I mean, of course, because the parliament, I mean, the prime minister.
They call him a thief.
Yeah, the prime minister, yes, is also the first among equals. He's also an MP in the first place, just that he's the leader of the majority party or the coalition, as
Thabo Mbeki was called a murderer in his face.
Yeah, he was referred to as a thief, and one MP said that, yes, it is said that the president is a thief, and they should allow that to continue. But it is important that we must also look at our culture. That's important. And we must also be conscious of the fact that we are also building a knowledge-based society. Okay. And that, nobody is a paradigm of virtue, and Parliament itself recognizes that. That is why in other jurisdictions, they will normally invite, if there's an area where they think that somebody has some serious expertise, the Congress or some of these legislatures will invite some individuals to come and share their experiences with them, proud to maybe taking decisions on certain specific issues and so on. So we can broaden that. Perhaps it's just a matter of recognizing somebody's expertise and saying that on this particular matter, we think that your input will be critical to the decisions that we take. So I think that in as much as I would say that maybe saying that they are ignorant will be too harsh. I think that Parliament itself, in a democracy, must also be a bit tolerant, in all of this.
And I'm not too sure I said they are all ignorant.
Yes, you said some members. Right. So if it's not the institution, if it's about some individual members, we could just be tolerant and say that, well, as we move on as a country,
in the same fashion, when we members of the public make certain comments that are obviously offensive to them, we should be honorable enough and admit and apologize.
The we one, it's completely reckless.
That's reckless.
Even if you say use or smoke, what do you mean by use or smoke? It's completely reckless.
So Black Rasta should rather start apologizing
Precisely.
from now.
I agree.
Before he appears.
I agree.
He's accordingly advised.
He's accordingly advised. He has not hired your counsel. He says he's got about 56 lawyers who have called him.
No, but
they are ready to lead him to the place.
What is bad is bad. I mean, it's not about having the lawyers and so on.
Okay. Now,
but legally, all the things we have said apply to him as well. I mean, if Parliament does not have the power, it may not surprise me that 50 lawyers are willing to help him.
It can be brought to the bar, subjected to the kind of treatment that others were done. Parliament can decide to refer. Yeah, so there's nothing lost.
I think to see that Parliament doesn't have the power is to beg the issue.
Okay.
They cannot impose a fine.
So that we don't go back there again. We have 10 minutes to wrap up the show.
Parliament cannot impose a fine.